prosecutor, Bondi, fired. And what Congress found when they asked her why. On a Tuesday, a career prosecutor filed a memo concluding that the Epstein names could be released. The law permitted it. The redaction standard did not apply. She put that conclusion in writing and filed it in the department's record system. On Friday, Pam Bondi's office removed her from the case. On Monday, a directive was issued reaching the opposite conclusion. The Epstein names were redacted. The memo was buried. And Bondi spent the next several months describing the release as complete and legally compliant until Congress found the memo. Then Congress found the prosecutor. And what the prosecutor told the committee under oath is the entire architecture of the DOJ's Epstein file strategy had been constructed to prevent from entering the congressional record. The hearing had already been running for hours before the prosecutor's name came up. Bondi had been at the witness table long enough that the rhythm of the proceeding had established itself with brutal clarity. Every question about the release produced a claim of completeness. Every question about the redaction decisions produced a reference to applicable legal standards. Every question about the names that had been protected, rather than disclosed, produced a statement about the complexity of the review process and the thoroughness of the departmental guidelines that governed it. The room had heard all of it before. In previous hearings and previous testimony, in the carefully prepared statements that the Department of Justice had issued at each stage of the Epstein file release. The story had a consistency to it that was itself suspicious. Not because consistent stories are inherently false, but because the consistency of this particular story was being maintained in the face of documentary evidence that directly contradicted it. And consistency maintained against documentary contradiction is not accuracy. It is something else. Jamie Raskin held up a document, not a new document. Not something that congressional investigators had obtained through a subpoena or a FOIA request, or the kind of aggressive document retrieval that oversight committees deploy when departments are not cooperating. A document from the DOJ's own files. A memo dated 3 days before the directive that governed the final Epstein release, authored by a career prosecutor whose name was still in the department's employment records at the time the memo was written, and whose name was not in those records 3 days after the directive was issued. The memo had a conclusion. Written in the plain, precise language of someone who has spent years drafting legal determinations and understands that the language of those determinations is what governs the actions that follow. The conclusion was this: the names of the individuals identified in the investigative record as participants in Epstein's trafficking operation do not meet the standard for redaction under the applicable statute. The statute protects victim identifying information. These individuals are not victims. Their identities are not protected. They can be released. That conclusion was not ambiguous. It was not a preliminary finding subject to further review. It was not a recommendation that required senior approval before it could be acted on. It was a legal determination, stated plainly, by a career prosecutor who had worked the investigation long enough to understand its evidentiary architecture and the legal standards that governed what could and could not be disclosed. The kind of determination that departments act on, the kind that becomes policy, the kind that in the normal functioning of a law enforcement institution operating according to its stated legal principles would have produced a release that included the names the determination said could be included. That conclusion was written by a career prosecutor, filed in the department's record system, time-stamped, preserved. It should have been the end of the question about whether the names could be released. Legal determinations filed by career prosecutors with direct investigative knowledge of the case they are analyzing are the institutional mechanism by which departments make these decisions. They are the product of the expertise and the case familiarity that the department employs those prosecutors to apply. When a career prosecutor who has worked an investigation for years concludes in writing that the applicable legal standard permits a disclosure, the normal institutional response is to treat that conclusion as the governing determination unless someone with the authority and the analysis to reach a different conclusion produces a documented alternative. No alternative was produced. And then 3 days passed. 3 days later, the prosecutor was removed from the case. 3 days after that, the directive governing the Epstein release was issued. The directive that redacted the names the memo said could not be redacted. The directive that protected the identities the prosecutor's legal analysis said the statute did not protect. The directive that produced the release Bondi had been describing, in hearing after hearing, as complete and legally compliant and the product of a thorough departmental review. Raskin read the memo into the record. The room went still in the way that rooms go still when something enters them that changes the shape of everything that has been said before it. Not dramatically. Not with the visible shock of something unexpected. With the specific stillness of people recognizing that a document has just made every previous claim in the proceeding require re-examination. This specific kind of stillness has a quality that distinguishes it from other kinds of hearing room silence. It is not the stillness of confusion, of people trying to understand what they are hearing. It is the stillness of people who understand exactly what they are hearing and are processing the weight of it. The reporters in the gallery understood that the memo changed the story. The committee members understood that the memo changed the available arguments. The aides along the walls understood that the memo changed the hearing's trajectory. And Bondi, at the witness table, understood all of those things simultaneously, which is why the 3 seconds that followed the reading of the memo into the record were the 3 most significant seconds of her testimony. Bondi was asked to explain the sequence, not to characterize it, not to provide context about the complexity of the review process or the applicable legal standards or the thoroughness of the departmental guidelines, to explain the specific sequence of events. A memo concluding that the names could be released, a termination 3 days later, a directive 3 days after that reversing the memo's conclusion. She said personnel decisions were confidential. Raskin said, I am not asking about the personnel decision as a personnel matter. I am asking about the relationship between a written legal conclusion and a subsequent policy directive that reached the opposite conclusion. If a career prosecutor determined in writing that these names could be released, and 3 days later that prosecutor was removed from the case, and 3 days after that a directive was issued reaching the opposite conclusion. What changed in those 6 days? She said the department's review process involved multiple levels of analysis. Raskin said the memo is dated, the termination is dated, the directive is dated. The dates are 6 days apart. That is not a complex review process. That is a sequence. And the sequence shows a written legal conclusion followed by the removal of the person who wrote it, followed by a policy directive that reversed it. What I am asking you is what happened in those 6 days. She said she would need to review the specific timeline with her staff. The timeline was on the table in front of her. Raskin said the timeline is in the documents. The memo date is in the document I am holding. The directive date is in the document the committee received from the department's own records. The only date that is not in the documents before me is the termination date, which the committee obtained separately. All 3 dates are established. The sequence is established. The question is not about the timeline. The question is about the decision. The binder opened. For a question about Tuesday, Friday, and Monday, the binder had a page about 4 years ago. The memo on the table was dated this year. It produced something about the previous administration's handling of the Epstein case, something about the failures that predated the current leadership, something about the long institutional history of incomplete disclosure that had characterized the department's management of the investigation before Bondi took office. Raskin let it finish. Then Raskin said, the memo I am reading from was written during your tenure. The termination occurred during your tenure. The directive was issued during your tenure. I have acknowledged in this committee and in other forums the failures that preceded your appointment. The question I am asking is not about those failures. It is about a memo written by one of your prosecutors, a termination that followed it by 72 hours, and a directive that reversed its conclusion. That sequence belongs to your tenure. Who ordered it? The room waited. Bondi said personnel decisions were confidential and the department's policy on specific personnel matters was not to comment in public forums. Raskin said, I am not asking you to comment on the personnel matter. I am asking you to explain the relationship between a written legal conclusion and a subsequent policy decision that contradicted it. If a career prosecutor's legal analysis concluded that these names could be released under the applicable statute and your department issued a directive reaching the opposite conclusion, the department has an obligation to explain the legal basis for that different conclusion. What is the legal basis? She said the directive reflected the department's considered legal judgment. Raskin said, the memo reflects a career prosecutor's considered legal judgment that the names could be released. The directive reflects a different judgment. I am asking for the legal analysis that supports the directive's conclusion over the memo's conclusion, not the personnel decision. The legal analysis, she said the department's legal conclusions were subject to deliberative process protections. Raskin said deliberative process protections apply to the process of reaching a conclusion. They do not protect the conclusion itself from congressional review, particularly when that conclusion reversed a prior written determination and was issued 3 days after the person who made that prior determination was removed from the case. I am asking for the legal analysis that the department relies on for its conclusion, not the deliberations. The conclusion and its basis. The binder stayed closed. Here is what the binder could not address. Not the political question of whether the name should have been released. That question can be argued. Not the legal question of whether the statute's redaction standard applied to co-conspirators rather than victims. That question has a defensible answer that the department could have provided. Not even the personnel question of why the prosecutor was removed, which is a legitimate area of executive discretion. What the binder could not address was the sequence, the specific, documented, time-stamped sequence of events that placed a written legal conclusion in the record 3 days before the termination and 6 days before the directive that reversed it. Because there are only 2 ways to explain that sequence. Either the department conducted a legal analysis in those 6 days that reached a different conclusion than the career prosecutor's memo, in which case that analysis exists and can be produced and reviewed. Or the directive was issued without a legal analysis that differed from the memos, in which case the reversal of the memo's conclusion was not the product of a different legal judgment, but of something else. There is no third option. There is no version of events in which a department can reverse a written legal conclusion without either producing the alternative analysis that supports the reversal or acknowledging that no such analysis was conducted. Those are the only 2 available positions, and both of them have consequences. If the analysis exists and has not been produced, the failure to produce it in response to a direct congressional request is itself a compliance failure that extends the documentary record of noncompliance. If the analysis does not exist, the directive that governed the Epstein release was not legally grounded. It was a policy decision dressed as a legal one, issued 3 days after the removal of the person whose legal analysis it reversed, without the legal foundation that would distinguish it from a decision made for reasons that had nothing to do with law. Raskin had asked for the analysis. She had offered deliberative process protections, which means either the analysis exists and she declined to produce it, or the analysis does not exist. And the directive that redacted the names the memo said could not be redacted was issued on a basis that has nothing to do with law. The hearing produced both possibilities into the permanent record simultaneously. And the permanent record does not require the department's cooperation to carry them forward into every subsequent proceeding that examines the Epstein file release. Then Congress found the prosecutor, not in that hearing room, in a separate proceeding in a secure setting under the authority of the committee's oversight jurisdiction. The career prosecutor who had written the memo, who had concluded in writing that the names could be released, who had been removed from the case 3 days after that conclusion was filed in the department's record system. She confirmed the memo. She confirmed the conclusion. She confirmed the date. She confirmed that her determination had been based on a specific reading of the applicable statute that she had applied consistently in her prior work on the investigation and that she had no reason to believe was legally incorrect at the time she made it or at any time since. She confirmed something else, something that the deliberative process protection claim Bondi had offered in the hearing room could not account for, because deliberative process protections protect the internal discussions that lead to a legal conclusion. They do not protect the absence of discussion. They do not provide cover for the failure to respond to a written legal analysis before reversing it. And what the prosecutor confirmed was not a discussion that had been protected from disclosure. What she confirmed was the absence of any discussion at all. She said that in the 72 hours between the filing of the memo and her removal from the case, she had received no communication from department leadership indicating that her legal analysis was incorrect or that the applicable standard had been interpreted differently. She had received no response to the memo at all. No acknowledgement, no request for additional analysis, no indication that her conclusion was under review. She had filed the memo on a Tuesday. On Friday, she was removed from the case. On Monday, the directive was issued. No response, no alternative analysis, no explanation, just the sequence. The absence of a response to the memo is itself a document. Not a physical document, not a filing with a date and a document number, but a fact in the record, a fact that the prosecutor confirmed under oath, a fact that sits in the Congressional archive next to the memo it describes the absence of a response to. The department had 72 hours between the filing of the memo and the removal of the person who filed it. In those 72 hours, the memo received no response, no acknowledgement, no indication that the conclusion it contained was under review or had been reviewed or would be reviewed before the directive that reversed it was issued. That absence, the specific, documented, confirmed absence of any departmental response to a written legal conclusion in the 72 hours before the person who wrote it was removed from the case, is what makes the deliberative process protection claim so structurally inadequate as a response to Raskin's question. Deliberative process protections protect discussions that occurred. They cannot protect discussions that did not occur. They cannot explain the absence of a response to a memo by citing the confidentiality of the deliberations that preceded the response, when the prosecutor who wrote the memo confirmed that no response existed to deliberate about. Just the sequence. The sequence is now in the Congressional record. The memo is in the Congressional record. The prosecutor's testimony confirming the memo and the absence of any legal response to it is in the Congressional record. The dates, Tuesday, Friday, Monday, are in the Congressional record. The directive that reversed the memo's conclusion without producing an alternative legal analysis is in the Congressional record. All of it is there. Next to Bondi's testimony that the release was complete and legally compliant and the product of a thorough departmental review. Next to the deliberative process protection claim she offered when asked for the legal analysis that supported the directive over the memo. Next to the silence that fell in the hearing room when the sequence was read into the record and the Attorney General of the United States said she would need to review the specific timeline with her staff. The names the memo said could be released are still redacted. The prosecutor who said they could be released is no longer on the case. The directive that reversed her conclusion is the governing document, and the legal analysis that would explain why the directive reached a different conclusion than the memo, if it exists, has not been produced. What exists is the sequence. Tuesday, a career prosecutor files a memo concluding the names can be released. Friday, she is removed from the case. Monday, a directive is issued reaching the opposite conclusion. 3 days, then 3 more days. 6 days total. 6 days in which the governing legal conclusion of the Epstein file release was reversed without a documented legal basis being produced, without a response to the memo that was reversed, and without the person who wrote that memo remaining on the case long enough to learn that her analysis had been set aside. Congress asked Bondi to explain it. She offered deliberative process protections and a written response that has not arrived. The written response was due before the next hearing. The next hearing came and went. The response did not. What the committee received instead was a letter from the department's Legislative Affairs Office indicating that the requested materials were under review and would be produced in accordance with applicable legal requirements and departmental policy. The applicable legal requirements and departmental policy had been the subject of the hearing that produced the request. The letter did not address that irony. Congress found the prosecutor and asked her instead. She explained it with dates. Tuesday, Friday, Monday, the rest. What happened in those 6 days, who made the decision, what the basis for that decision was, why the memo received no response before the termination and no alternative analysis before the directive, is what the written response that has not arrived is supposed to contain. It has not arrived. The dates are in the record. The prosecutor's testimony is in the record. The memo is in the record. And somewhere in the Department of Justice, if the legal analysis that supported the directive over the memo exists, it is in a file that has not been produced to the committee that asked for it and found the prosecutor who proved it should exist. The dates do not require interpretation. They don't. Context matters. Analysis matters. The legal framework matters. All of those things can complicate a sequence and make it mean something different than its surface reading suggests. But complicating a sequence requires engaging with it, requires producing the context and the analysis and the legal framework that explain why the sequence means something different than what its dates say, requires the department to sit in a hearing room and account for the distance between Tuesday and Monday and the career prosecutor who was there on Tuesday and gone on Friday. The department did not engage with the sequence. It offered deliberative process protections. It offered a written response that has not arrived. It removed the prosecutor before the directive and produced the directive after the removal and described the release that resulted from the directive as complete and legally compliant and the product of a thorough review. Congress found the memo. Congress found the prosecutor. The prosecutor confirmed that the memo said what it said and that no one responded to it before she was gone and the directive was issued. The sequence speaks for itself. It has been speaking since Tuesday, and it will keep speaking. In every subsequent hearing that references the memo, in every subpoena that builds on the committee's request for the alternative legal analysis, in every proceeding that examines the relationship between a written conclusion and the termination that preceded the directive that reversed it, until someone in a position of authority sits in a room and provides the explanation that Tuesday, Friday, and Monday are still waiting for. The prosecutor's testimony did not end with the committee session. What she provided: the dates, the memo, the confirmation of no response, open requests for additional documentation that are still pending, the alternative legal analysis that would explain the directive, the communications between department leadership in the 72 hours between Tuesday and Friday, the record of who authorized the removal and on what basis. Those requests are in the committee's formal record. If you want to know what comes back when they are answered, or what the silence means if they are not, that is what this record is here to follow. The prosecutor wrote her conclusion and filed it in the record system and waited for a response. The response never came. What came instead was a Friday and a Monday and a directive that said the opposite of what she had written. And then Congress came, and she told them everything: the dates, the memo, the absence of a response, the sequence, all of it, under oath on the record, in the permanent archive of a proceeding that the Department of Justice did not want to happen and could not prevent once Congress found the memo and realized that the memo meant there was a prosecutor to find. 3 days. That is still the distance between the conclusion that the names could be released and the termination of the person who reached it. The names are still redacted. The memo is not.